ask you, what level are we doing this at? I mean, I didn't understand us to be talking about entire documents. I thought the court was going through and looking at particular communications, almost like the segregability requirement in the FOIA context. Am I wrong about that?
You're not wrong. It can be segregable at all the way down to the sentence level, which is the district court in certain instances here did order redactions at the
All right,
sentence
so
level.
if I'm right about that, I guess I'm trying to understand what is a dual purpose communication. Because if you were in a document and you're going sentence by sentence or line by line, trying to assess, is it legal, is it non-legal, you're doing that exercise and you seem to admit that there are going to be some that are clearly in one bucket or the other. So are you just talking about the sentences or the paragraphs in which it's kind of hard to tell, is it legal or non-legal? And if that's the world of dual purpose communication, why is it that when we're in that ambiguous circumstance, it should essentially automatically be deemed legal?
So that is the world in the sense of, now it might be at the sentence level, it might be at the document level. It's very hard to prophylactically say it's always going to be at this level or another. But someone goes in and asks a lawyer, should I fight for the house in the divorce? There's property, there's legal part of that, and there's probably emotional and personal parts of that, and it's tied together. So you can have situations where it's very hard to disentangle, if not impossible to disentangle.
But I mean, you're in the document, you're looking, there's a paragraph that describes the house, and it's all factual, and would you agree that that would not be privileged because it's just the facts?
Well,
no?
Not necessarily. It really depends on the context, because if the purpose of describing the house is to inform the lawyers so that they have the facts in order to bring a legal judgment about is it marital property, is it not, when did you buy it? That would be really important.
Is that really how we ordinarily do attorney-client privilege? I thought even parts of an attorney's memo that had factual information aren't covered by the privilege.
Well, the underlying facts are never privileged. That is, you can always get those. But the communication of those facts, that's right out of Upjohn. So when they went and interviewed employees at Upjohn, the communication of information to the lawyers was privileged. The government, of course, could go out and interview the same people and get the same information. What they couldn't get is the communication between client and lawyer, if that communication was for the purpose of the lawyer then rendering legal advice. So it does, sometimes the transmission of facts by client to lawyer is privileged. That's a very typical situation.
You're saying the amount doesn't matter. So we have this memo, it's about the divorce, and 90% of it is the description of the background facts, and we have a sentence, the lawyer says X. You're saying that because the whole thing was created for the purpose of legal advice, it's covered under your view?
If the proponent can meet that burden, then yes. And the problem is if you tip the other way, if you say, no, it's got to be 51% legal, it's got to be primary, it's got to be the single biggest. A conscientious lawyer, when you get into these mixed purposes, is going to have to advise a client. We are now in a world in which we're talking about legal and non-legal. I need to advise you. A court might later say this is not the primary purpose, and therefore it might not be privileged. So it's going to create a chill on that communication, because a lawyer who takes the test seriously is going to need to say to her client, I can't be confident here that this is going to be privileged in a confidential communication.